Welcome to this webinar presented by Family Councils of Ontario, the role of caregivers and substitute decision makers in long-term care. The guest speaker for this session is Lisa Feldstein. Family Councils of Ontario leads and supports families in improving quality of life in long-term care. We do this by working collaboratively with our partners to cultivate effective family councils, mobilize knowledge exchange, and advance public policy, system planning, and research. And now it is my pleasure to turn over the webinar to this afternoon's guest speaker, Lisa Feldstein. Thank you for joining us this afternoon, Lisa.
Thank you so much, Samantha, and thank you to everybody who logged in today. This is a topic that I think is very important because there's a great deal of misinformation out there and a lot of information that just doesn't seem to circulate very often. And so before I begin the webinar, I thought I would just spend a moment to introduce who I am and why this is a topic I'm speaking on. So my name is Lisa Feldstein. I'm a health lawyer in Ontario. My practice is focused on a niche that I call family health law, and that means the majority of my clients are family caregivers. And previous to this practice, I actually served a lot of hospitals, long-term care homes, and other institutional clients, but I recognize that often family caregivers and other friends and supportive people to residents and patients didn't have a lawyer or didn't have a voice. And so that's the gap that I've been trying to fill over the last few years, is the advising and advocating for family caregivers. And so that leads to this topic today. And so to start off, I will begin with a disclaimer, as you might expect from any lawyer, that today's presentation is not legal advice. Of course, I can't give advice to anybody through your questions because it may actually be that I'm counsel to an opposing party, for example, and I can't get into any kind of conflict of interest, and I also won't have all the facts of your case. So I do ask it in your questions you keep them general in nature. And it's also not legal advice because this is a complicated area of law, and I will try today to make the law as simple and clear as possible. But in doing so, that means I will be leaving out some of the details that would overcomplicate the presentation. And this is an area of law that involves a web of multiple statutes. And so I won't bore you with always the statute names and the section numbers, but it does mean that there's some information that won't be included, and I would not want you to rely on only part of the law and reach the wrong decision in your circumstances. So the focus of today will be all about substitute decision makers, and I'll define what that means, and I'll differentiate it from the term caregiver. I'll address common misunderstandings about substitute decision makers, and those are misunderstandings held by families, by substitute decision makers, and often healthcare providers as well. And I'll go through different types of substitute decision makers, and that's where this area of law does get quite complicated, as there are different categories. And with each category comes different collections of powers and duties, and sometimes somebody might be the substitute decision maker in one category but not another, and so I will try to dispel some of the myths and the confusion relating to those matters. So when I use the term caregiver, I mean that in the broadest sense possible. I don't mean a hands-on healthcare provider. I actually mean supportive friends and family. And so it's not a legal term. You won't see the word caregiver in the legislation, but it's a word that I use because it's important to put it side by side to explain what a substitute decision maker is and what it's not. So to me, caregivers are people who play the role of advocates. They may seek help or a second opinion or a referral for a resident. They may act almost like healthcare providers. Sometimes family members take on the role of nurses, OTs, and occupational therapists and PSWs. You might help your loved one with brushing their hair, helping them do their exercises, or reminding them to take their medication. Sometimes a caregiver might act like a secretary, keeping track of appointments, making phone calls. And then some of the time they are also a substitute decision maker, in which they do step into the role of making decisions on the resident's behalf. So that's just one part of what a caregiver might do. So the term substitute decision maker I define it loosely here as a person with legal authority to give consent or make decisions on behalf of the resident. But the truth is there are actually multiple definitions of substitute decision maker. And if you look even in the Healthcare Consent Act alone, there's more than one definition. And if you look in the Long-Term Care Homes Act, it's a slightly different definition. And the reason there are multiple definitions is because they all turn on these different categories of decisions. Generally speaking, though, a substitute decision maker is usually a spouse or adult child, and in this presentation I will help you figure out who is the substitute decision maker for a resident in a very practical way. And I'll help you figure out for the different types of substitute decision makers how you recognize those categories and who makes those decisions. And so because it's such a broad category, I've included the umbrella image because that really signifies what substitute decision maker means. It's an umbrella term, and under that umbrella are different types of substitute decision makers. And it may actually be that one person fills that role in all the different categories of decision making, but it may actually be that it's more than one person acting as substitute decision maker for different types of decisions within a resident's life. And based on those categories or those types of decisions, there are different powers and duties that come with it. And the final note is a substitute decision maker in many cases is a responsive role. It's a role where a person steps into it because a decision must be made. So for example, someone at the long-term care home might say, I suggest this resident take a particular medication. Now the substitute decision maker has to decide to consent or not consent, but it's very much a reaction to something that has been proposed. Whereas it's one of the misunderstandings, and we'll talk about that in 2 slides, is a lot of people think that substitute decision maker is a very proactive role, and it's often not. The other important term to be familiar with in this field is the word capacity, because in most cases, a substitute decision maker has no legal authority to act unless the person, and in this case the resident, unless they are incapable. Usually it's only when the person is incapable that a substitute decision maker has to step in and start to make decisions. If a person's capable, they can make decisions for themselves. And that includes decisions that you or I may not think to be in the person's best interests. And that's sometimes a really tricky part for family caregivers, is my loved one is making a decision that isn't in his or her best interest. How can I stop this person? How can I get him or her to do something differently? But if they are capable in the law, they are free to make decisions as they wish. And there's one noteworthy case from a number of years ago where there was an older woman spending a lot of her money on jewelry. And it seemed like an unwise use of her money. And it did go to court. But at the end of the day, the decision was, this was a capable decision. She knew what she was doing with her money. She got joy from buying jewelry. And it was her right to spend her money as she pleased because she had the mental capacity. She passed the test for capacity to manage her property. And this can come up in healthcare decisions as well. A very common example that's given is some people of the Jehovah's Witness faith decline blood transfusions, even if that would mean saving their life. And a lot of people struggle to understand how could somebody decline a treatment that would save their life. But provided they are capable, they can choose not to consent to a blood transfusion. And so as I've sort of referenced now a few times, there's different types of capacity. And so that pie chart image can help you visualize that there are different categories, and they're all part of the same pie or the same person, but the law has sliced different types of decisions into different pieces. So there is no global incapacity. We don't say that a person is either capable or not in a black and white sense, or that they're incompetent of all decisions. It's very piecemeal. And that is done intentionally because by slicing it into categories, we are able to preserve people's autonomy to the greatest extent and only section off certain types of decisions that they aren't capable, but leave the rest for them to make for themselves. Because whenever we talk about substitute decision making, what we're also talking about is infringing on someone's liberty and their autonomy and their right to make decisions for themselves. And that can be very intrusive. Sometimes it's necessary because people are vulnerable or no longer can make safe decisions for themselves. But that's the balancing act that always arises in this conversation. And the final note on this side is there while there are different tests, I don't mean a standardized test. Some of you will be familiar with clinical tests, mini mental status exam, and maybe you've heard about tests to assess dementia, or you've heard about people being asked to draw a clock. That's actually not what I mean when I'm saying test. The legal tests are really more of a conversation than anything. There's not one standard set of questions, but it's the health professionals and the various people who have the legal authority to make the assessment about capacity. They have to have essentially a conversation, and they probe somebody's understanding. And through dialogue, it's often possible to find out, does someone really understand what we're talking about here? And we'll go into more detail on the other slides about what those tests for capacity actually look like in more detail. So it's often the misunderstandings about substitute decision makers that lead to conflict. And people who come to my office have conflict with other relatives and sometimes with healthcare providers or even the long-term care homes. And so I hope with this slide to clear up some of those misunderstandings. And one of them is that the substitute decision maker is responsible for providing all of the caregiving. And the reality is, in most cases, the substitute decision maker is making decisions depending on the category, maybe some proactive steps as well, but it's not intended to exclude other people from being involved in the person's life or the person's care. I recently had a client who said, my loved one needs socks and underwear and a jacket, and the person who is the substitute decision maker isn't getting those things. She's allowed to go out and buy a pair of socks and bring them to dad. Now, I'll park the question about whether, she gets paid back, because property is something we'll talk about later, but setting aside the money part, she's allowed to go buy socks, give them to dad, and play a role as a caregiver, even if she's not legally the substitute decision maker. And likewise, it's not true that only the substitute decision maker can speak with staff. Of course, there are privacy laws, and the staff are trained in what the privacy laws are, and in some cases some information can only be provided with consent. But the existence of a substitute decision maker is not in itself a wall that prevents all dialogue between other supportive friends and family and a resident. And in fact, with consent, almost any information can be shared. It's also a misunderstanding that only the SDM is the short form, of course, for substitute decision maker. It's not only them who can speak up on behalf of a resident. If somebody were to notice bruises on their friend, for example, maybe they want to point that out to the staff. They don't have to wait for the substitute decision maker to come by or make that phone call. So the existence of an SDM doesn't prohibit somebody from playing some of those other caregiving roles that I mentioned previously. And then finally, and this last one is something that has come up many times and led people to seek legal advice from me, is this idea about substitute decision makers following the resident's direction. I mentioned previously, sometimes we need a substitute decision maker to essentially protect people from themselves. And if you are to follow someone's direction who has been found incapable, it may actually be that that's a disservice and not compliant with your legal duties as the substitute decision maker. It may be they aren't capable and their decisions aren't wise decisions for themselves, and they're not capable decisions. And sometimes in an attempt to foster independence and frankly to smooth the road, because certainly some clients have told me about the behavioral issues and the conflicts that they face with their loved one. And I had a client who basically said his mother throws temper tantrums and it was easier to comply with her wishes. But at a certain point, sometimes those decisions can put somebody at risk. And so it's important to know when to foster independence and when to recognize that there's a line, and as a substitute decision maker, you may have to make a decision that isn't exactly what the resident says he or she wants. So here are the categories that tend to come up in the context of long-term care and substitute decision-making. And these are each standalone categories. There's an element of overlap, of course, but there are 5 common categories of substitute decision-making. And each of these will be addressed in turn through the presentation. But I will note that not every single decision is captured by these. For example, there is no role for a substitute decision-maker to consent to medical assistance in dying, or another term other than MAID is now the lingo, but You may be more familiar with the term physician-assisted dying or physician-assisted suicide. That's not something a substitute decision maker can consent to. Same with sexual activity. A substitute decision maker cannot provide consent on a resident's behalf. So not all decisions are covered by these categories, but most of them are. So the first one I'll address is property, and the property category typically includes all property: money in the bank, real estate, artwork, jewelry, vehicles. And to become someone's substitute decision maker for property, there's three main paths to that role. And often people do get into some legal trouble because they don't actually have legal authority. And most people start getting involved because they want to help their loved one. Maybe your parent asks you for some help to start paying bills. This often arises if a spouse dies and it was the spouse that was responsible for paying bills, and it becomes a slippery slope of helping somebody into going into really managing their finances. And that slippery slope is hard to pin down when that transition happens, but it can get some people into trouble if they don't have authority, particularly if there is the potential for family conflict. Because what one person is doing to genuinely help a parent or somebody else, it may be perceived by another person to be taking advantage of the person, and they may be accused of theft or even of elder abuse. Sometimes police complaints are made or lawsuits are started based on a misunderstanding or suspicion. And so it's very important when we talk about property for people to understand that there are certain laws in place, and you really need to have legal authority to do certain things on someone's behalf with their property. So the three main ways someone can become the substitute decision maker over property are listed on this slide. And the first is one most of you are probably familiar with. That's a power of attorney for property. That is a legal document that a person can sign in which they name someone to make property decisions on their behalf. And this is a role that is not just reactive, but proactive as well. It can involve managing property, paying bills, maybe selling a home, paying for long-term care. But that's a document that can only be signed when if a person is capable. Again, there's another test for capacity here, the test for capacity to make a power of attorney for property. And some people who have some cognitive impairments are no longer capable. And this can create quite the legal mess if a document is signed and it's really unclear if a person was capable at the time. It's very challenging for the staff at the home and challenging for the families because there can be confusion around whether it should or should not be followed. So the best idea is to sign powers of attorney for property at a stage in one's life where their capacity is not called into question. So everybody listening should have one. I have one myself. It's not something that needs to wait until you're older. Any of us could become incapacitated at any time. And so this is a document that is very useful to appoint someone, and some people go further and make specific wishes that they want followed right in that document to give direction to the person. And a person who is appointed under a power of attorney, they are referred to as an attorney. Some people refer to them as a power of attorney, but the POA is actually the document itself. The person acting is called an attorney, and they do not have to be a lawyer. The word attorney really means their agent acting on their behalf. The other way to manage someone's property legally is to become their guardian. There's two ways to do that. One is through court, and sometimes that's the only option. Maybe there is no power of attorney, or it's not valid, it may not have been witnessed properly, and so there is a way to go to court. A judge, of course, must be satisfied that the person truly is incapable of making property decisions and that the person applying is suitable to be the guardian. And that's a drawn-out process. It actually takes several months. It costs thousands of dollars, and it can be avoided if someone had just made a valid power of attorney for property. And then the third way of becoming this decision maker over property is ultimately a type of guardianship, but through a process that I won't explain here. Sometimes the public guardian and trustee gets involved and becomes in control of someone's property, and family members can often apply to the public guardian trustee and replace them, and then they become the guardian. And what can be very challenging is sometimes none of these things are in place. There is no power of attorney for property. It's too late for the resident to make one, and there's currently no guardian. And this is where it does often make sense to seek legal advice, because sometimes there are people who really do need someone to intervene and make financial decisions, but doing so without authority can get you into hot water. So I've tried to very briefly summarize the powers and duties that come with attorneys and guardians. Generally speaking, a person who's the attorney or guardian for property can do anything with the person's property except for make a will. Of course, it may be actually a little bit more reined in than that, because the power of attorney may have some specific language, and the guardian has to follow a management plan that they have prepared and that has been reviewed by the public guardian and trustee, and that plan may set some limits as well. But then there's also the law, the Substitute Decisions Act, and there's a bundle of law that applies to people who are guardians and attorneys. The guardians tend to become aware of this because to become a guardian, the public guardian and trustee is involved, a lawyer may be involved. Typically someone will at a certain point mention to you there are legal duties that you have. It's the powers of attorney that get people into trouble when they have no idea that there are a variety of legal obligations that they must comply with. And if they don't, the consequences can be quite serious. They can be sued by other family members. They may have to pay the legal costs of those other family members, or even the resident, who often will have a lawyer appointed. And in some extreme cases, attorneys and guardians, for that matter, have gone to jail. And so it's very important that attorneys and guardians become familiar with their legal obligations to comply with the law, to protect the interests of the resident, and also, frankly, to protect themselves. Personal care is the other side of the coin. Often when we talk about powers of attorney and guardianship, you'll hear about property and personal care. Those are two sides of the coin. And there's a different test for capacity to make a power of attorney for personal care than there is for property. So sometimes someone is incapable of making one, but can still make a power of attorney. For usually it's personal care that they can, even if they can't make one for property. So the phrase personal care, what I mean by that are the categories listed on the slide: healthcare, nutrition, shelter, clothing, hygiene, and safety. And unlike property, which is a little more black and white, if someone is incapable, the guardian or attorney for property can make all property decisions. Personal care gets a lot more complicated because a person may be capable of some of these categories and incapable of others. And it can be very challenging for everybody involved to nail down which are the categories of which this person does and does not have capacity. And to make it even more confusing, capacity can fluctuate. It is entirely possible somebody who's capable today is not capable in 2 months from now, and 2 months later they have regained capacity. And it can fluctuate based on someone's condition, based on their medication, and so it certainly can make it very challenging in practice to deal with fluctuating capacity, as it's called. So the authority for personal care decision making, it comes from the Substitute Decisions Act. And just like on the other slide, there's two ways: power of attorney for personal care and going to court. That third option from the other slide does not exist here. It is not possible for the public guardian and trustee to become the guardian of care and then for a family member to apply to replace them. So there's really only two ways to become the decision maker for personal care. And the authority, when it kicks in, it may be for only some of these categories. So for example, someone applying to court may ask the judge to find the person incapable of only some of these categories and to appoint them as guardian of only those categories of which the person is incapable. Clothing is one that often comes up, where a person who may not be capable of some of their decisions is perfectly capable of clothing decisions. They wake up in the morning, they choose their own clothing, they're dressed appropriately for the weather and for the circumstances, and they don't need a guardian over that category. Now the banana is here actually as a reminder for me to tell you a little bit about the kinds of decisions that may come up under the category of nutrition. And as many of you will know, when someone's in long-term care, substitute decision makers may be involved in what the person eats. And situations that I've spoken about with clients have involved wanting to have some say in diet. So the banana came up in one case where a client was concerned about her father eating a very large number of bananas every day. He had freedom to choose what he was eating and was choosing so many bananas that his potassium levels were increasing, and she was worried about how this could potentially affect his heart. So she actually wanted to exercise her authority as attorney to limit the number of bananas that he was having. Other categories under other kinds of decisions I've seen come up is people who want to resist medical interventions to deal with constipation, and they want to try to explore options through diet first. So those are the kinds of decisions that may come up under the nutrition category. I think some of the others speak more for themselves, and if somebody's already in long-term care, it may be there's not much to decide under shelter anyway. So the duties and the powers are summarized here, and the reason I say may is because, again, for each of these people, anybody who's acting as attorney or guardian, their specific powers may be limited by what is actually written in the power of attorney or the court order that grants guardianship. They're not all identical, so it's may because some of these categories may or may not be included, and I won't read them all out. And then duties, just like with the guardian and attorneys for property, there are legal duties on people who make decisions, whether they're an attorney or a guardian. They must encourage the person to participate in decisions to the best of their abilities and foster contact with supportive friends and family. This one comes up frequently when there's conflict in the family and allegations of trying to keep somebody from seeing certain people. So there is actually a duty to foster contact. The language is a little bit more lengthy than just that, but that's the essence of it. And just like with property decisions, there are record-keeping obligations. Everybody who's an attorney or a guardian should have record-keeping systems in place, whether it's with their binders or Excel spreadsheets, but there are actual legal duties to keep track of various decisions and store different documents, and a lot of people fail in those duties, not simply for lack of trying, but because nobody ever told them that they had those duties in the first place. And it can be after the fact, particularly with property, somebody is asked to produce those records and they try sometimes years later to reproduce them. And you can imagine recreating financial records years later, especially if cash was involved, is a nightmare, and often it's practically impossible to do. And it creates red flags if it's in a context of allegations of theft and abuse. And so sometimes those records can be the best way to defend against those kinds of allegations. Treatment is yet another category. And when I said healthcare under personal care, somebody who's actually the attorney or the guardian of personal care, that healthcare category encompasses treatment. But this is where it can get a little bit more confusing, is even if someone has no guardian and they have no attorney, there is still always a substitute decision maker for treatment. And on a subsequent slide, I think it may actually be the next slide, you will see a list. And that list comes from the Healthcare Consent Act. And the reason that list exists is this idea that we should all have a decision maker for treatment decisions. Somebody could get in a car accident, it's an emergency, there's no time to make a power of attorney, it's not like they were diagnosed with an illness and had some advance warning, and we all need somebody to step in and make decisions for us. And so under the Healthcare Consent Act, there's a list that is actually a hierarchy, and we work our way from top to bottom, and we'll look at it on the next slide. And so we all have a substitute decision maker by default under the law for our healthcare decisions. If we have a power of attorney for personal care, that attorney would make our treatment decisions. But if we don't, it's the list on the next slide. So the term treatment is actually defined in the Healthcare Consent Act. It's lengthy, so I won't read it out. I only flag it because sometimes questions come up about the scope of the authority of a substitute decision maker, and it's useful to know that the Healthcare Consent Act defines treatment, and that there are some decisions that may clearly fall inside or outside of the definition. And so I said I would tell you what the test for capacity is in some of these areas. So the test for capacity for treatment is reproduced on this slide. It comes from the Healthcare Consent Act, and it's a two-part test. You'll see 2 bullet points there, and I flagged the word able for both of them, because the test is not does a person understand information, but are they able to understand information relevant to making a decision about the treatment and they must pass both parts. Are they able to appreciate the reasonably foreseeable consequences of the decision or lack of a decision? So the importance of able is useful reminder because we can sometimes overstep the really important piece where we make sure someone has the opportunity to understand. Maybe there's a hearing impairment or a language barrier, or maybe the person is just so new to discussing medical terminology that the information needs to be explained in a different, perhaps simpler way. Maybe the person needs breaks due to their condition. And so able is really the reminder that we can't just jump to say someone doesn't understand it. We have to see, are they able to understand and appreciate the information? And then if they are, and they do pass that test for capacity, they can make a decision as they please, even if it's not what you, as the caring family member, would decide for them. And in all of these areas, capacity is actually presumed. We don't have to assess every single person for every single type of capacity. Our healthcare providers are usually able to presume that a person has capacity, unless there are reasonable and probable grounds or red flags, you might say that maybe they don't. And then in those cases, it might be the healthcare professionals ask a few more questions and think a little bit more about whether they can take instructions or accept consent from somebody. But in most cases, it is actually presumed, and again, that protects all of our autonomy to make decisions for ourselves and be given the benefit of the doubt that we are capable of making all of our own decisions. And I put another pie up there. This one is in the same color because I mentioned in personal care, all of these different categories are treated separately. Someone might be capable of decisions with respect to clothing, but not treatment. Treatment is actually further subdivided. Every treatment decision stands on its own. This is a big misconception where a healthcare professional might say the person was found incapable. And the question to ask is incapable of what? There is no legal concept of being totally incapable of all treatment decisions, although that may actually be the case with some patients or residents. But actually the law divides it up so that it may be someone is not capable with respect to making decisions about a surgery that requires a higher level of understanding. But a simpler form of treatment, maybe their diabetes medication that they've been on for years, maybe they do pass that test for capacity. And so look at that test and those 2 bullet points, and can they understand the information relevant to their medication for their diabetes, appreciate the reasonably foreseeable consequences of a decision or lack of a decision. So it may be that that test applied to diabetes medication they pass, and other medical or treatment decisions they do not pass. So who is the substitute decision maker for treatment decisions? Here's the list. And to help walk through it, I'm going to use Marge Simpson as our patient or resident in question. So for Marge, if she needed a decision maker, and whether you're a family member or health professional and you're trying to figure out who do we ask, Marge is not capable. For simplicity, let's say she's temporarily unconscious and so there's not any question about her capacity. Who is her decision maker? So the first person on the list would be a guardian. This would be a court-appointed guardian, and most people don't have one. And her family would know if she did or didn't, because they actually have to be, the immediate family member has to be notified or served is the legal word with a guardianship application. So they would know. And actually it's possible to call the public guardian and trustee and state a person's name and ask, does this person have a guardian? And so that's a very easy way to find out if a person does or doesn't have a guardian of the person. So let's say she doesn't. Next on the list, attorney for personal care. So we would say, Homer and Marge's family, does Marge happen to have a power of attorney for personal care? And if so, and provided it's valid, whoever she appointed would make her decisions. And Marge may have wanted to make a power of attorney. It may be that she decided that her daughter Lisa Simpson is really the best person in her life to make her healthcare decisions, and so she wanted to make sure that that is who she could appoint. Because if she didn't have a power of attorney, number 3 on the list she most likely would not have. That's someone appointed by the Consent and Capacity Board. I won't say much about that now other than to say it's a legal process where, kind of like a court, where somebody can apply to be appointed for decisions. So it's it's more narrow than the guardian, but I won't get into too much detail now, as most people do not have that. And so then we look, and it would be spouse. And so if Marge never took any step to make a power of attorney, Homer would be her substitute decision maker. Whether that's a good or bad thing is somewhat irrelevant, but it may be that maybe the healthcare providers feel that Homer himself is not capable of making decisions. He's found incapable. Or perhaps she's older, he's not in the picture. For whatever reason, if it's not Homer, then it's a child or parent. And if she's in a long-term care home, it may be Marge's parents aren't in the picture, her children. So Bart, Lisa, and Maggie, all together, they are equally ranked substitute decision maker as her children. And so they have to actually decide together. And if they can't, then it may go to the public guardian and trustee to decide. But otherwise, all three together. And the long-term care home cannot pick which of the three they like best or who's making the best decisions. They're all equally ranked substitute decision makers. And then if for some reason none of them are in the picture, then her sisters would be the SDM, and following that, any other relative. If there's truly no one, the public guardian and trustee can be called upon. And that does happen from time to time. There's somebody who maybe they're a widow, maybe they have no children or no family nearby. Maybe there's no one in their life that can, that falls into this list. It may be the public guardian and trustee is involved. Or number three, which again, I'm not going into too much detail, it could be that a friend applies to basically get permission to be appointed as the substitute decision maker. And so it's through number three that someone who's not otherwise on this list can apply and step into the role to make treatment decisions. So the rights of a substitute decision maker for treatment decisions are briefly summarized here. And at its core, it's the right to provide informed consent. So anything that a patient or resident would have the opportunity to know. So the risks and the benefits of the proposed treatment, side effects, the alternatives, that informed consent conversation just happens with the substitute decision maker instead of the resident. And that is an essential part of a substitute decision maker being able to exercise authority and to do a proper job, is to have that informed consent discussion, because they're replacing the decision. It's a substitute decision in the most literal sense for the resident. And then the second point, likewise, they need to have all that information to make the decision. And often that does mean having access to the resident's health record, because they may need to look at that documentation to make a truly informed decision. And once they have that information, now they get to decide, do they want to consent to the proposed treatment, decline, or withdraw consent, which literally means they can consent and later change their mind. So another category of decision-making is admission to care facility. And once your loved one is already in long-term care, this may not come up. So I won't say too much about it. This is also under the Healthcare Consent Act, and it really parallels treatment. It's the same test for capacity and the same list of substitute decision makers, but just modified as applicable for decisions about being admitted to care. So what I mean by that is consenting to for a person going to long-term care, because consent must be granted for a person to be admitted, and if a person's not capable, their substitute decision maker decides whether to consent or not to that admission to long-term care. And I did reproduce the list, but it is the same as the prior list. And the rights are essentially the same again, but they're just modified as they apply to making decisions about long-term care. But otherwise, it is parallel to decisions about treatment. And likewise, personal assistance services rounds out the trio under the Healthcare Consent Act. Virtually the same test for capacity, same rights, even the duties. So they're under the Healthcare Consent Act, there's actually legal principles that a substitute decision maker must follow to make their decision. And they're modified based on whether we're talking about treatment, personal assistance services, or admission to a care facility, but they are virtually the same. And again, here's the list, but I won't go through it as it is the same as the substitute decision makers for treatment and admission to a care facility. And again, the duties are very similar. And for all three, the substitute decision maker has to comply with the Healthcare Consent Act. I summarized it very briefly to say when they make decisions, they have to follow a person's prior capable wish. which means when the person had the mental capacity, if they expressed a wish and they were over 16 years of age and the wish applied to the circumstances, and if it didn't apply or they weren't capable, if there is no known prior capable wish applicable to the circumstances, it's best interest. And I won't go through all of the factors, but I do want to note that best interest has specific legal factors. So substitute decision makers actually must look at the factors set out in the law when making their decision. It's not a general sense of intuitively what's in the person's best interest, but there's very specific factors that must be considered. And if the substitute decision maker doesn't seem to be considering those factors, their decision may actually be challenged at a legal tribunal called the Consenting Capacity Board, and there can be an entire hearing, which is very much like a court procedure. They can be cross-examined on their decisions, there's evidence, there's lawyers, and at the end of it, a substitute decision maker may actually be ordered to consent. So it's very easy to fall into the role of substitute decision maker and not know that you have legal duties, powers, but also with your obligations, there are healthcare professionals who can actually take you to a tribunal if you're not complying with your legal obligations. And so now I'll turn to some of the rights that have to do specifically with the Long-Term Care Homes Act, and that's what LTCHA is, the Long-Term Care Homes Act. It's an Ontario law that regulates long-term care homes. It's very, very lengthy if you've ever looked at it. So what I've attempted to do is pull out some of the pieces that talk about what rights the substitute decision maker has. And so this is more about their rights than their obligations, but I did put an asterisk because what's interesting is if you look at the Long-Term Care Homes Act, you will see the word substitute decision maker, but the way it's defined is actually quite interesting. It's basically defined in reference to the other types of substitute decision makers. It refers to the other laws. So in the next 3 slides, when I'm referring to substitute decision maker, it may be I'm referring to a substitute decision maker for treatment or property. So under the Long-Term Care Homes Act, they're all kind of lumped together, but it may be that the substitute decision maker doesn't actually have the right, all of these rights. And that's when we have to take that step back and say, well, is there a power of attorney? What does it say? Is there a guardian? Who is the substitute decision maker for this particular right? So essentially they have the right to be involved in the resident's care plan and all kinds of decisions that might be made by a resident if they were capable. There's usually a role for the substitute decision maker to play, providing input at care conferences, being notified when personal aids or equipment are not working or require repair. And there can actually be a lot of overlap in the long-term care context around care and property because, of course, there's a cost to long-term care, and there are services and various personal aids or other kinds of belongings that need to be paid for. And the home can't provide everything, and they don't provide everything. And so there's a necessary overlap. Even admission to long-term care, it involves the admission to care decisions, but also property. The person who does have authority to make property decisions has to say, yes, we're going to pay for this. And so it may be that it's one person. Maybe someone made powers of attorney and appointed the same person, but it may be that you're actually dealing with more than one substitute decision maker. It's not unheard of to have one person appointed as attorney for care, personal care decisions, and a different person making decisions for property. And when those people don't agree, that can become a real problem for them, the resident, and also the home that can get caught in the middle, and they're not always sure who needs to agree. And so there is some guidance in the law about what trumps what and how those decisions are made. And it may be that there's guidance right in the management and guardianship plans that the guardian makes or right in the power of attorney. So again, I go back to my comment that every situation is unique, and so you really need to look at the facts of that case to decide how they are resolved. And so here's some more rights. A lot of these are more personal care in nature, and the substitute decision makers, I won't read all of them, but if there is some kind of allegation or suspicion of abuse or neglect, they do have to be informed of that and notified of the results of the investigation. And then any kind of leave will involve a substitute decision maker. Maybe they do need to leave for medical or psychiatric absence. It may not be possible to notify the substitute decision maker immediately. If something happens, the home will call 911, the paramedics may arrive and transport the person to the hospital, and so it's not reasonable to make a patient or a resident suffer and have to sit around and wait. So it may be after they have been transferred to the hospital that the substitute decision maker ends up being informed. And then casual and vacation absence as well. The substitute decision maker and home really have to work together. The substitute decision maker is part of that conversation, but also has to notify the home, assume the responsibility when they're out and let the home know if their return has changed. So it's important that there's a dialogue there between the SDM and the home. And the substitute decision maker must be informed of any restraints used on the residents, notified about adverse reaction, about discharge. And so again, I go back to my comment about there's different categories here. So it may be that the person to notify about adverse reaction is the decision maker for treatment. And so the challenge is always, when we talk about substitute decision making, is to take a step back, and this really brings me to my final thoughts, take a step back to say, what category of decision are we talking about? Think of that pie in different slices. Are we talking about property decisions, treatment decisions, or broadly that personal care category? And for each of those categories, is the person capable or not? That's really the first question, because if they are, the conversation ends there. The person themselves will give consent or decline to consent, and there is no substitute decision maker. And with that question of are they capable or not, to make it a little more confusing, some of these categories, the determination about capacity must only be made by certain qualified professionals. So under the Substitute Decisions Act, we have capacity assessors. Under the Health Care Consent Act, we have capacity evaluators. And actually, some people may fall into one of those categories and not the other. Not all health professionals fall into both of those categories. So we have to figure out who is the person that even can make the decision to help us really clarify if they're capable or not. And sometimes it's optional. Sometimes in trying to figure out is the power of attorney now in effect, if it's drafted in a way that's not so clear, sometimes we do bring in professional capacity assessors to meet with a person to decide, help us decide, are they actually capable right now or not, or are they capable of making a power of attorney or not? And so we have to divide up the categories, and then from that it will flow, what authority do you have? If there is a power of attorney, you look at the POA and the Substitute Decisions Act. If there's a guardian, they look at either the guardianship plan or the management plan and the Substitute Decisions Act. So with each category, we have to go back to the legal source of authority to find out what are their duties and what are their powers. But in all cases, I would suggest substitute decision makers document well. And healthcare providers, I always hear the recommendation to document well, because when things are going well, that's fine. But sometimes when things go poorly or there's conflict or potential for conflict, documentation can be your best friend to defend the decisions that you have made or explain the decisions that you've made. And I also remind you not to make assumptions. I think despite trying to make this seem simple, it's clear that this is not a simple area of law. There are many categories. There's a lot of intersection of different areas of law, and intuition will not get you the answer you need in all cases. Mom or dad may be clearly incapable, and yet legally they're still capable of making their own decisions, and that doesn't always make sense to people, but those kinds of assumptions do get people into trouble. Be proactive where you can through asking questions, getting assessments if you need to, documenting, seeking advice, because the more you can be proactive, maybe you can even get somebody to make a power of attorney while they're still capable. Of course, it's something we all must make for ourselves. You can't make it for another person. But sometimes if you're proactive, you can save yourself a great deal of trouble. Retroactively, though, if you're creating records after the fact or trying to figure out where cash went, it can become a real mess and really expose people to a lot of liability. And finally, when in doubt, seek professional advice. And I mean a variety of professionals, whether capacity assessor or evaluator as applicable. Often it's lawyers, of course. Sometimes it's health professionals. Sometimes it's social workers or occupational therapists to help figure out what a person's capacity is or what their needs are or what their limitations are. And sometimes bringing in a professional can really nip conflict in the bud and avoid things from escalating to a place where you find yourself resolving a situation in court. Thank you so much for joining us today. I hope that you learned something, and feel free to get in touch if you do have any questions about this topic.
Thank you very much, Lisa, for taking time out of your probably very busy schedule to speak to us this afternoon on this very important topic. We will be wrapping up now, and this webinar has been brought to you by Family Councils of Ontario. For more information on our educational sessions and other guest speaker presentations, please visit our website at www.fco.ngo. And on that note, we will conclude this afternoon's session. If you have any follow-up questions for Lisa or on our other topics, please don't hesitate to get in touch. You can email us at info@fco.ngo. Thank you very much for your attendance, and have a wonderful rest of your day.